Now, one person we did hear from today for the first time, Karen Reed herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, here we go. Talking about Karen Reed today in her hearing, she was certainly ticked off, whatever you want to call it. Got on her last nerve. Certainly Hank Brennan looks very strong for the Commonwealth, and it looks like he's going to get a lot of the things that he asked for today's hearing. Karen Reed, of course, pulling faces, acting like a petulant child in court. The usual Karen Reed, off-tone Karen Reed that we've seen before, where her defense attorneys look concerned or at the very least appropriately faced. And there's Karen Reed making faces, turning around. I really was shocked that the judge didn't say what she said before. Excuse me, Miss Reed, you find this funny? But no such comment today. She was allowed to, once again, act inappropriately in court. And outside court, she had a few words for the press. Let's go backwards. So we're going to watch her reaction to today's hearing, and then we're going to go into the hearing. So this is from Julie Carpenter's on X. Thank you.
Jonathan.
Yes.
Isn't it amazing that ABC, NBC, Boston Magazine, and Fox all sat on alleged confessions and never publicized it? That's malfeasance on all your parts if that were actually true. That's a fishing expedition. They don't exist.
And are you
Jonathan.
Yes.
I'm going to play it one more time, okay? So what she's saying is what they're looking for is they're looking for unedited footage from her TV interviews and, of course, the unedited tapes and off the record and Gretchen Voss's notes. So Gretchen Voss gave tapes of her interviews, and the redactions, I think it was like an crazy, I think they said today in court that was 75% of the second interview was redacted, 150 redactions in 2 interviews. Gretchen Voss, who did the first article, which I'm going to get into, which really set the narrative in this case, and which I consider an innocence fraud narrative. Karen Reed slept so much that night. She did this, that, reporting it from Karen's own words as if it's the truth. And Gretchen Voss, again, had a lawyer in court saying, I'm not going to hand it over. Gretchen Voss, who went to the rolling rally, And she's really fighting, handing over these unredacted tapes. Why? What is she saving them for? Her big Netflix series? She's sold to Netflix. It's going to come out after the trial. How is that going to be helpful to John O'Keefe and his family? Just hand it all over. Who's paying for her lawyer fees? I assume it's Boston Magazine. But what a waste of money. Just hand them over. And you'll hear in court, there's really no laws. She's not basing this on any laws. Her lawyer got up in court today, sorry, spoiler alert, and said, like, look, you said last time we didn't have to hand them over. Isn't that good enough that we didn't have to do it last time? So what? So it should go this time. Samesies defense.
Isn't amazing that ABC, NBC, Boston Magazine, and Fox all sat on alleged confessions and never publicized it? That's malfeasance on all your parts if that were actually true.
It's not malfeasance. We know that the press will go with a fantastical story. We'll push an innocence fraud campaign. We'll edit things together to make people look innocent, to push this innocence fraud narrative that the police are arresting, pushing cases on innocent people, that the justice system is convicting so many innocent people often. We've seen it before again and again. Serial, anybody? I mean, that whole podcast left out a whole ton of evidence. And when they did bring up damning evidence, they dismissed it. We've seen it again and again and again. It's not malfeasance. It's an innocence fraud campaign, which Karen Reed is very familiar with. Here she is reading the Staircase lawyer's book, Michael Peterson's lawyer's book, about innocence fraud. She's reading up. And she announced this weekend, we'll get into that in another episode, that she's going to be basically an advocate, devote her life to advocacy for the wrongfully accused, which they always use the word wrongfully accused, even when people are wrongfully convicted. So it's all the press's fault. These confessions don't exist. There's nothing I admitted on those tapes that could help in any way, shape, or form the Commonwealth. And that's why I'm paying lawyers good money to fight it. I don't want them all to come out. So she knows it looks bad for her to say, like, hey, I don't want these tapes out. They don't exist. I'm going to get ahead of it and say there's nothing on there that's damaging. But I'm going to fight like hell to release their release. It's actually not her lawyer that's fighting it. I mean, as far as Gretchen Voss, but goes, that's Gretchen. It's Boston Magazine's lawyer, I think. Gretchen Voss's lawyer. We'll get into Gretchen Voss later on, but let's get into the hearings and later on your comments. I'm going to try to keep this short and do this in 2 parts. Let's see how it goes.
And good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right.
Also, thank you. Mr. Jackson appears via Zoom.
Okay, we can't see him though, Jim?
Yeah, we can't see you, is that okay?
That's correct. All right, good morning.
So Alan Jackson is on Zoom, watching it on Zoom, not there in court. And if you remember last time, he was like, look, I'm going to have to make the red eye. Thanks, 65CJ5, for the super sticker. Appreciate it. B. Tim, nice to see you. So Karen Reed's new grift is to create a 501c3 to do more innocence fraud projects and to give herself and her friends big paychecks. Right? That is a grift. Charities can be a grift. But more than that, it gives her narcissistic supply. She gets to go around and charge money for her speaking and events and gets to play the victim. Poor me. I was wrongfully accused. Now, if she gets convicted, that's going to limit her advocacy quite a bit. Depends on if she's convicted and for what charges. But it certainly hasn't been helpful on this side of the fence to say, like, hey, what is this second degree murder charge? She did it by mistake. She was drunk. I mean, I hear so much of this. And I think maybe for another episode, it would be a good idea to go through how you prove intent. What that means when you're looking at car data with someone with their foot 75% on the pedal, going in reverse with an infotainment system beeping at them, flashing at them, louder and louder. They could not miss that. I mean, if you drive a car regularly, you know your car is almost like a appendage, like an arm or a leg. You're so familiar with it that when you're going 24 miles an hour in reverse and your infotainment system is beeping and flashing louder and louder and louder and louder at you, you're going to hit something. You're going to hit something louder and louder. It's really hard to say you didn't know you hit something. And when you told your father and you made an admission, she thinks she hit something. She knew she did something terrible. Not something like, hey, I just love tapped my car into John O'Keefe's car. That was the argument Elizabeth Little's going to make in about a minute and a half. It sounds ridiculous, but we're going to listen to her make it. Nice to see you, Shelly F. Thanks for the super sticker.
Mr. Jackson. All right, we have several motions this morning. Let's start with motion for admission pro hac vice that you filed. And Ms. Giannetti, I know these are freely granted, but I have a question about here. So you say good cause exists to grant this motion because Mr. Alessi has specialized skill and knowledge in representing defendants in matters of this nature. What do you mean?
Mr. Alessi is somebody with decades of experience in the courtroom, both on an appellate level and on a trial level. He has handled many criminal cases over his career. I have actually consulted with him on a criminal matter. I know of no better trial attorney in the country than Robert Alessi.
So Karen is adding a new lawyer, Robert Alessi, to her team for one part of it. Perhaps he's really good. Maybe they're anticipating all this car data. And he's going to say it's all misconstrued, wrongly got after, not reliable. I'm curious. I have to do a little bit more research into Robert Alessi and see what his strengths are. But curious if that's going to be it or something else they're anticipating. But not really believing that Karen Reed is $5 million in debt. Here's more money for another lawyer. And she seems to be, designer clothes keep coming and her hair is still perfectly coiffed. Heisenberg says, Karen has nothing to hide but wants to fight this information from coming out. She knows the walls are closing in on the BS crap. Yeah, and her supporters are leaving the Free Karen Reed group. She had a big event this weekend and they weren't invited. It was the Cool Kids Club and the people were there at every hearing outside in the rain, wind, or snow. A lot of them weren't invited. A lot of them have left. So, but the smallest showing was, of course, again for the O'Keefe family. So you can look on Karen Reed's side of the court; it's filled up, and there's John O'Keefe's family and a few people.
Aspects of our defense that would greatly benefit from his expertise. I'd rather not go into the specifics in terms of the division of labor on our team, but I'd ask the court to, take judicial notice that with his background, with his experience, he is going to add value to this team and protect my client's constitutional rights.
Okay, so he's not a criminal lawyer, but he's a lawyer who does some criminal work. I just don't understand what you mean by representing defendants in matters of this nature.
Right, of this criminal nature. He has represented criminal defendants throughout his career.
Okay. All right, thank you. All right, so let's go on to the...
How many other people thought of Breaking Bad? So he's a criminal lawyer? You need a lawyer who's a criminal. That's what I'm thinking. Listening to that. I don't understand. He's a criminal lawyer. What exactly do you need him for? Miss Reed, how many lawyers now do you have on your team? 4, 5? What are we doing here? Just packing. This is becoming O.J. Simpson too. Just packing your side with lawyers.
Discovery motions. We'll start with the requested records of Mr. Reed. I'll hear you, Mr. Brennan.
There's a much better relationship between Judge Cannone. Is it Cannone or Cannone? Cannone, right? And Hank Brennan than Adam Lally. She seems to really resent Adam Lally, dislike him. I thought was kind of awful to him, frankly, in the first trial. Hank Brennan is a defense lawyer. Judge Cannone was a defense lawyer before she became a judge. She seems to treat him well, and they have a good rapport. There's one moment in this where she's looking for a number of a document, and Hank Brennan has it. I was thought, well, that's a way to win brownie points. Judge Cannone really likes to have those documents, numbers at her fingertips, not wait around for things. Thought, good on you, Brennan, for getting that documented. Heisenberg, before we go into Brennan says, I read somewhere that the chatter on YouTube is for them to just forget about not receiving the invite, such as for them to just forget about not receiving the invite, like just forget that you weren't invited. Just such a smack in the face to her supporters, her really on the ground supporters. Yeah, some of them, very public faces were not invited. We can get into that maybe some other time. There's so much to talk about with Karen Reed today in this hearing. Let's get back to it.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days for Janet Reed. The Commonwealth has a burden with 2 of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Miss Reed knew she struck John O'Keefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a strong, plain likelihood of death. In a second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally struck somebody left them behind, and didn't render aid knowing that there's a strong potential likelihood of death.
Okay, so that's a really important point, and I hope you had your eyes and ears open for that. So what he's saying is that we have the highest, very high burden in this case to prove a second-degree murder charge, right? That she intentionally struck him, or that she didn't mean that it was an accident, but that she had knowledge that she struck him, and that she knew by leaving him that she was causing serious injury or death. So we can go, so the jury doesn't have to be unanimous either way. They can choose, it can be either of those things. And we can argue them that the likelihood is one of the two. But those are the things that comprise a second degree charge here in this case. And it's so important. So when I think the phone calls that Karen left, I hate you, John, that this was a product of her rage, are very important, and to not be dismissed like, oh, she didn't know what she did. She couldn't have missed it with that infotainment system, could not have missed it. And who needs to go 24 miles an hour in reverse anyway? How many times have you gone 24 miles an hour in reverse with your foot 75% on the pedal? She knew she struck something. That's what her dad said. So they went her dad's phone records 30 days. Her mom's phone records 30 days. Let's see if he gets them. 30 days seems an awful long time, but I wouldn't be surprised if she narrows that, if the judge agrees, but let's see.
When Miss Reed knew that she struck John O'Keefe is a critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to convince that Miss Reed knew she hit John O'Keefe when she did, the government's entitled to the full value of their proof. The records for 30 days, to begin with that aspect of William Reed's records. Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She calls both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind. 30 days.
Okay, so the fact that she called her parents at 1:30 in the morning. My father is no longer living, but my mother still is. And I don't call her past 8:30. So she goes to bed early, as elderly people tend to do. And most people, you don't call most people, right? There's a polite time to call people. So she's calling in the impolite hours, in the emergency hours of 1:30 a.m. And the call is unanswered. And she's making phone calls and she's making arrangements. And then she gets the idea early in the morning to have John O'Keefe's niece start calling people, because she gets more and more conscious of making evidence as she goes along. There's always one with Karen Reed. She likes to have buffers between herself and her evidence, right? So make her own evidence and make some plausible deniability. Well, it was, I don't know, Kaylee who was so wanted to call all these people.
Period is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone. just the call records, because I expect it will establish that there are no other calls in that 30-day period from Miss Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
Okay, so here's a pattern in practice. So what he's making is saying that it was unusual. So why once 30 days, which I thought was unusual. We know that no other day is important, right? Before this. No one is saying that she plotted this out with her parents. Although I do think that there is a possibility that she could be fantasizing about doing something like this, as her relationship, as we knew, was deteriorating with John O'Keefe, and that this is the end result of relationship violence, meaning that there was coercive control on Karen Reed's part over John O'Keefe. And we can have talked about that a little bit, and it's shown in the text messages. It's talked about in the testimony of the children in the home. Karen Reed would punish John with silent treatment, fly into rages. You can see the pattern of texting him when he wants to be left alone, calling, texting endlessly, not respecting his boundaries. So that's what he needs the 30 days for, to make a pattern, show a pattern that this was unusual for Karen to call so early in the morning. And I think he would find that pattern, and look at Karen's face there. She seems to get it. That a fair jury could rightfully infer that there was something about that night that was unusual. You know, when people say it was a normal, an ordinary day, you know, it wasn't. It was just an ordinary day until there was something extraordinary about that night that she needed to talk to her father at 1:30 in the morning.
No. There were 2 search warrants from Miss Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies. The 2 search warrants from Miss Reed's phone are from a period of January 28th, 6 p.m. to January 29th at 6 p.m.
Okay.
And the other one is January 28th, 9:30 to January 29th, 5:30.
Okay.
And so they're not in Miss Reed's records. I am not looking to see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Miss Reed and her parents the 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable.
That is great. This is what's looking like a pattern with Hank Brennan. He's like, well, if the defense wants to open it up to 6 months to a year, I'm amenable to that. They want to give me her father's records for a year and show that she called her father all the time at 1:30. I'm open to it. Like, let me call your bluff. If this is so unimportant, let me do it. Like, hey, get the whole year records. Why not? Show me how many times she called him at 1:30 in the morning. Let's take a guess. Never in that year. I think the chances are 0.0. And how sharp is his suit? This is what I'm looking at, his thick tie and his vest and his suit. These defense attorneys, they got the big bucks for the sharp suits. This is a specially appointed prosecutor. If you're coming in late on this case, Hank Brennan, who also defended Whitey Bulger. So he is usually defense attorney, but been appointed as a special prosecutor in this case, working on this case with Adam Lally, who prosecuted this case. First time around where we got a hung jury. And I don't like to make any, what I've heard is that there were 2 Karen Reed supporters on the jury. And it didn't matter really. And if that's the case, it didn't matter what they argued. That's another thing I keep hearing, that the first time round, the prosecution didn't argue it correctly. Well, we don't know if that's the case. If it wasn't a fair jury, we don't know. We don't know what happened in that room, meaning the jury deliberation room.
But in the absence of any other calls, it is terribly remarkable that she is panic calling her parents at 1:30 in the morning. And here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain to create bleeding so it wouldn't swell, or they could have cracked his cranium. Now, certainly he would have suffered significant impairment, but I expect the government is pursuing a witness, and my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father. Nothing else am I interested in. The second part is the 24-hour period with William Reed. The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial. The time of the phone calls to Miss Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, in your first discussions, my motion leaves off the S in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it'll be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Miss Reed's phone for a couple of reasons. Number one, phone records often show different communications. Sometimes calls or hang-ups don't register on a phone, and so they could be different. Secondly, I've learned that Miss Reed's phone was sent to a taint team, and the Commonwealth does not and should not know what, if anything, was redacted from Miss Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But what I do know is we cannot say...
So they're saying that we cannot rely on Karen Reed's phone to show incoming calls from her father or outgoing calls to her father, because her phone was sent to a team that could have Tink team. Is that what he's saying? Am I hearing that correctly? Tink team. I've never heard that phrase before. That could have redacted. So the defense got Karen's phone and was getting information off of it, they could have redacted some of the information that they got before they handed it over to the Commonwealth. So it's very interesting. He's like, I know all the defense sleazy tricks. You send it to the Tink team. They get it. They get a few things taken off. Might be. They might be different records. We don't know. Hand it over. I love that. I'm amenable to a whole year of his records. Janet Gardner, nice to see you. Thank you. Karen knows he's got her pegged as a psychopath, and she's showed it out front of the court house today. I love Brennan. I say a conviction. Hope so. I think picking the jury doesn't matter how good Brennan is. Again, if you have people on who refuse to deliberate and will just say she's innocent, cross their arms and say she's innocent, I'm not budging. They can keep us in this room for days and days and days. I don't know how many people have been a juror. So I have the benefit of being recently a juror. I know I talk about this a lot, but I really learned a lot on a criminal trial, learned a lot about that experience. When they lock you in there, and I think we asked to get out for like a quick, I think we had a terrible smoker on our team. I was like, dude, like, you didn't bring a lozenge or what? I thought this guy's going to go crazy. Luckily, it was 11-1 guilty first vote, and I wasn't the holdout, and the smoker wasn't the holdout, but they let us out. But once they lock you in there, you really get that feeling like, I will do anything to get out of here. I will do anything. Like, I might agree to anything just to get out of here. So it really does take a lot of willpower to really to hang a jury like that. And if you look at the juror foreman's note, like, what he was saying was, we can't go any further because we're dealing with beliefs, not evidence. They don't want to talk evidence. They want to talk beliefs. That's very different than discussing the evidence. So I think, Janet, I hope you're right. I hope we get a conviction. It's very interesting to watch the difference between Lally and Brennan. Their styles are very different. Certainly, Brennan is a much more TV-ready, performative, as defense attorneys often are, lawyer, more easily digested. Lally seems a very shy man, does not enjoy the cameras, does not enjoy public speaking, spoke in a monotone very quickly, smart. I felt he proved his case, but certainly not someone that I would want to watch try. I don't find him entertaining the way some other lawyers are. Brennan has a lot of flair, as defense attorneys often do.
Say that the records from Miss Reed are a full accounting of her records, and so that Mr. Reed's records stand separately from Miss Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's.
Thank you, Janoni woman. Brennan was a former prosecutor too. I meant to mention that. Yes. And he's considered damn good here in Boston. I bet.
Records, all I am looking for is call subscriber information and phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Miss Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor.
Your Honor, the defense.
So my friend brought up to me that maybe Elizabeth Little took allocution classes What do you guys think? I didn't think so, but she thought that her presentation was a little bit clearer. Her voice was stronger. Let me know what you guys think.
Defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th, from not one, but 2 separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy so that the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is, that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at CF McCarthy's. And he wasn't present at the water.
So again, the same kind of response. This is a new trial. Now, 3 years into litigation, she always sounds like she's complaining to me with these. Now, can you believe it, Your Honor? 3 years into litigation. Now they want these phone records from William Reed and your mother. I mean, come on. No way. Like, it's very, it comes off very whiny to me. Anyone else? It just bothers me. It's just such a grift. I mean, wouldn't you want to just release all these if you were innocent? I get that there's privacy, but they're not asking for text messages. They're trying to show a pattern in his calls. They're not looking for, it's not a fishing expedition like Karen Reed said. That's what she does. That's what she did on Proctor's phone. That's what she did with the federal investigation. That's what she does on Facebook. Go back to my last couple episodes, more than a couple episodes. Been talking about this. Karen Reed. Smear campaigns to embarrass you. That's what the defense does. With all their Facebook pictures of all the witnesses. The bang bang video. Give me a break.
On January 29th, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night. The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all 4 elements of Lampron were met. Here, the Commonwealth has failed to meet its burden, to meet even a single prong of that 4-part test. In regards to the burden...
Are there any Massachusetts lawyers know what land prawn is and what the 4 prongs are that they have to meet? I wish she went through them to say what they were. They haven't met their burden and they don't deserve them. It's essentially what she's saying. Curious. Hope there's someone who knows what it is. And she's like, and this phone call didn't exist, this unanswered phone call.
That they have to establish that the records are evidentiary and relevant. The Commonwealth, in its affidavit, set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's character is...
What? Like, they just made some vague reference to an interview. The interview where she said, that interview, which sticks in my mind so much in this case. William Reed's interview. I don't know about anybody else, where he says, yes, my daughter said to me, I think I struck something. Hugely important. Hugely important. Other thing that sticks out to me very much is that Karen Reed seemed to be psychic. You can go through that another day, but knew exactly when to start kicking the door. Let me out, let me out. No one else saw anything, but Karen Reed knew right where to go. Hugely important to prove intent. That she either hit him unwittingly or knew that she left him. Now, I'm not on board of the hitting unwittingly. I think she hit him purposely and left him purposely. But she knew right where to go, right where to direct. Let me out, let me out, let me out. Everyone else sees nothing. But Karen, let us not forget it was a nor'easter. So those facts stick out to me. To say that this interview was unimportant is absurd.
The foundation of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, I believe I hit something, was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning. The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion.
So there's one time where Hank Brennan misspeaks and Karen Reed looks back like, can you believe this? What a clown, everyone, all my supporters, tosses back her hair. And here you have Melanie Little making a pretty 4-letter word misspeak almost with an S and hitting, sounding like together. No toss back of the hair, no look back to her supporters here. Hey, Pumpkin Parker, thanks for becoming a member. I appreciate it. But she's like, we know what she hit. She love tapped John O'Keefe's car. That's what she wanted to talk to him about. That's what was notable. A love tap that left no pieces of her taillight anywhere. And that she seems to purposely do to make some evidence that she hit something else. So ridiculous. I always think of John Lewin, DA John Lewin, who's been on this channel a bunch of times. He said, if I wanted to say things I didn't mean in court, I'd become a defense attorney. I mean, she knows her argument. She doesn't have any real belief in Karen Reed's innocence, or she's just going through the motions, doing what she can for her client, which is what defense attorneys do.
Itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon. The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So
Right. So they're saying this 1:30 call doesn't exist, and what Hank Brennan's saying is that we may see a call that was redacted, or we may see a call that didn't show up on one phone because when you hang up too early or it's not answered, it doesn't show up. But I wouldn't be surprised if she did try to call both of her parents that night. Hank Brennan seems pretty sure that she called both of the parents that night. He wants both phones. Let's see how it turns out.
the frequency at which Ms. Reed called her father's cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron was also not addressed in the Commonwealth's affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found." Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m.
If they felt they were going to win this motion, why didn't they have Unetti do it? And not Elizabeth Little. She's the rookie on the team. She's the one who tends to make less important arguments or question the less important witnesses. I think they know they're going to lose this motion. I think they would have gone to Unetti or to Jackson. Have him there for it. And I don't think they can prove that this is not a fishing expedition. I think Hank Brennan was pretty clear as to why he wants it. And it's how it's limited. He's like, hey, if you want to open it up, if there's really nothing there, you get to the point where you're arguing, if there's really nothing there, what are you worried about? There's only that one call, guys. There's only that one call. Well, then what are you worried about? Then there's nothing. Then the Commonwealth has nothing. I would have expected a lot more argument on privacy grounds, that they don't have the right to it for privacy reasons. But he's a witness in a very serious case. And he's involved himself. He's stood out there in front of the courtroom with a megaphone and said, my daughter's factually innocent, and given interviews. So it's a little hard to say that he needs privacy now. Oh, man. I'm going through this rather slowly. All right.
After she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17. This unsupported request is overbroad and must be denied. Thank you.
All right, thank you. Did you want to respond in any way, Mr. Brennan, or move on?
Very briefly.
Okay.
In between the multiple accusations of bad faith, what the attorney says that is most telling is they don't know who answered the phone. That's a harbinger to trial. The prosecution doesn't know who answered the phone when Karen Reed called her parents or her mother's phone at 1:43 a.m. No, the Commonwealth doesn't. And so we have to prepare that when Mr. Reed takes the stand, we have phone records demonstrating all of his phone calls and that he had control of that phone, so there can't be a suggestion somebody else was handling the phone. Or, on the other hand, if the position is going to be that Janet Reed answered the phone, the father's phone, or that William Reed answered the mother's phone, then we'll call both witnesses at trial and we'll sort it out. But it is that very nature of suggesting confusion or uncertainty that the government is obligated to try to prevent at trial. And we're being diligent, we're being studious, and we're going to be prepared. And these records will help us do that. That is the exact point and reason why we need these records. Thank you.
All right, did you want to respond at all?
We're going to be diligent, we're going to be studious, and we're going to be prepared. That's why we need these records. If they want to suggest that her mother really answered her father's phone at 1:43 in the morning, go right ahead. We'll be prepared for that too. We'll call her as a witness. I'm very curious why they didn't call any of the Reeds, especially her sister-in-law, to the stand. First time round. Just curious why this was not done first time around. We were all asking the question at the time, why aren't any of the Reeds called to the stand? Why aren't they witnesses? And Gretchen Voss may have to be a witness in this case. That sure would be interesting. Heisenberg says, thank you. Her dad said she felt, thank you, she struck something. That was 2 points of contact she acknowledged, very smart, Heisenberg, to her dad. Not one, a big difference against her. Great point. I'm going to say that. I'm going to read it again. Her dad said she felt she struck something, which is an experiential language. So she felt it, which you would feel it as you struck something in the car. Not she thought, she felt it. Great point. Really smart. Thanks.
Ms. Little?
Well, I think the Commonwealth actually brought up the issue of, it tried to basically say, I need the Verizon records because Karen's phone records don't establish that Mr. Reed answered the phone. But all I'm saying is that neither do the Verizon records. So there is no additional information the Commonwealth is going to obtain by digging through Mr. Reed's private cell phone information.
Okay. All right, so we sort of overlapped a little bit with Mrs. Reed, Janet Reed's records. Do you want to be heard?
Kimmick, I was just going to say the same thing. I was just going to say the same thing. I was like, oh, I'm short for time. Jude looks like doesn't he look like Mr. Burns on The Simpsons, especially when he puts his chin down and his eyes up? Doesn't he? Doesn't he? He's such a cartoon villain.
Further on that, Mr. Brennan?
No, I believe the court understands my argument unless the court has any questions for me.
I don't, but thank you. Ms. Little, is there anything specific to Mrs. Reed that you want to address?
Yes, Your Honor. Again, I just emphasize that the affidavit in support of the request for Ms. Reed's phone records is plainly insufficient. They haven't addressed numerous elements of Lampron. That alone is a basis to deny the request, and it's not permissive. It's mandatory that the court deny the request. Lampron.
When are the Karen Reed Lampron wasn't met shirts coming? Lampron wasn't met. If Lampron wasn't met, no phone records you get. What is that? What is that argument coming? And the shirt to match. They always have to accessorize their defense and monetize it.
It's very clear. If you don't meet a factual showing in the affidavit in support of your Rule 17 motion, then the motion must be denied. 3 of the elements were not even addressed in that motion. So on that basis, we request that the court deny the motion.
Okay. Thank you. All right, so we will move along now. Both of those are under advisement. We'll move along now to it's paper number 405, Commonwealth's renewed motion for all audio recordings, notes, emails, text messages, voicemails, and the possession of Gretchen Voss and or Metro Corp. I do have an opposition that I received this morning in an affidavit from Robert Birch, attorney Robert Birch, who I think is present in court. So, Jim, did he file an appearance too?
He has previously filed an appearance.
And we'll use that in this case as well. All right, so Ms. Little, you did not intend to argue that, right?
No, Your Honor.
Okay, so Mr. Brennan, I'll hear you, and then Mr. Birch, I'll hear you.
The Commonwealth has filed a motion to reconsider in part, and in addition, there is a request for information that was not requested before by the Commonwealth. Your Honor made a ruling in the past to turn over portions of the materials, and in that ruling, it invited the Commonwealth after review to renew or reconsider the motion or the extent of the motion. I've had an opportunity to listen to the hearing. I've had an opportunity to review all of the pleadings relative to the Boston Magazine and Ms. Voss information. And I've had the benefit of observing numerous other statements that have been made by Ms. Reed publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline, 2020, Vanity Fair. And after a review of all those materials, it is clear that there is significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Yeah, that would be helpful.
And there were 2 different interviews that were turned over. One was represented at the last hearing, that it was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing, not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided. And so there wasn't just a few redactions, they were significant. In addition, which is notable, and you can...
Right. So I believe he's talking about Gretchen Voss's redactions in her 2 interviews that she tape recorded. And he said one was 2 hours and they got 19 minutes. Did I hear that correctly? 150 redactions? What is Gretchen Voss thinking? Hand it over. Hand it over. Let me blow your mind a little bit more with how Gretchen Voss is protecting Karen Reed. I mean, does she think that this tape is the acorn that's going to grow a great oak? And she's going to use all this material in her Netflix special or monetize it some other way that benefits her? But not only that, it appears someone else has heard the unredacted interview. Let's take a listen.
What we know is that what has been put into public are admissions and conflicting stories, right? So,
Right.
I mean, I think the Commonwealth is entirely justified in saying, well, let's see the rest of it. And the reason being is in the form that it's in right now, I don't know that it would be admissible, right? Because it's not complete. So in order to be able to use that, it would be proper and appropriate to ask for the complete recording or, or, you know, not just what was broadcast. And I think even what was broadcast, I mean, I've listened to 2 interviews that she's done where she's made statements where she's essentially agreeing with the Commonwealth theory on what happened, right? That's not good for your case.
Did I hear that correctly? Did Gretchen Voss play Kate Peters, her interviews? Or is she talking about, now that I'm listening back, is she talking about the edited interviews she heard on tape? It sounds like, you know, that they're friends. I don't know. What do you guys think? Going to hear from her lawyer in a second. But she's the one who set up this narrative from this Boston Magazine article. The O'Keeffes wouldn't talk to her. It was all from Karen Reed's perspective. Everything Karen Reed said, it became the narrative that everyone went with. Pushing this innocence fraud story out to the public, and it's like a virus that just nobody can get rid of. Everybody's afraid to stray from this narrative. And it's nice to see Hank Brennan in here getting in more material. That was from Innocence Fraud Watch's Rumble channel.
Glean this from the transcripts is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times, and Attorney Jackson 33 times. And so there are significant interruptions and redactions in both recordings. These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redacted portions, there is conversation or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements. That bears directly on the credibility of the witness. Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of a defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so
I think also what Hank Brennan is saying here, that she made so many statements and so many contradicting statements. She tells Gretchen Voss that she sipped on water that night. That didn't make it into her article. Why not? I mean, clearly shown not drinking water that night at the bar. I was just sipping on water. I was just there to hang out. I wasn't really there to drink, she says. Heisenberg, last main point I want to make tonight. Well, you're making a lot of good points tonight. Thank you. Since she knew she hit something twice, she felt she hit something. Karen had 2 chances to check behind her car that night, and she didn't. And strangely, what's missing is that morning when she showed her broken taillight to Jennifer McCabe and Carrie Roberts. Strangely, that video's missing. Isn't that interesting? Almost like someone erased the evidence, which I find very interesting in relation to this hearing, where Hank Brennan is saying, we don't know about Karen Reed's phone. We're not sure it's entirely accurate. We're not sure the defense gave us anything. If they did the same kind of special editing where we didn't get this Ring camera video evidence, it seems to have disappeared. It would be interesting to know if Hank Brennan can prove something was erased in a more convincing way this time round. But certainly everything that is presented in trial is evidence. Testimony is evidence. So when Jen McCabe and Carrie Roberts said, she showed me this broken taillight, it's evidence. But boy, would it be nice to have a video of it. Isn't it interesting? They're under the same strange delusion that Karen Reed showed them the taillight. And when do you hit something and not check? Which is Heisenberg's point. You always get the first thing you do when you hit something in your car, if you're a driver, is you get out and check. You have a fender bender. What's the first thing you do? You get out and check. Check if whatever you hit is okay. Not Karen Reed. Karen Reed wanted to speed away and dial John O'Keefe and let him know that he was a pervert. I don't know how to say it. YouTube friendly. She hated him. Screaming at him, swearing. Because the entire act was an act to let John O'Keefe know and the world know how much she hated him. At this point, she was done with the love bombing. She had gone on to devalue, and she had discarded him at this point. He was no longer a source of narcissistic supply, no longer needed. And in fact, John O'Keefe wanted her out of the house. She wouldn't leave right before this. Things were deteriorating. But this is at the end of the cycle of this kind of abuse. So first you love bomb and you give a lot of attention and they're the world and everything's fantastic. Then they devalue and then they discard. And Karen Reed discarded, and she wanted to let John O'Keefe know how much she hated him and the world how much she hated him. And when she was asked after trial one afternoon if she loved him, he was my boyfriend, she said very coldly, meaning no. We were dating, she said.
It's not only what she says in the interview, it is what is missing in the redactions. Now, certainly, there may be discussions in those redactions that involve her attorneys and Ms. Voss. But none of that is protected. None of that is protected. A defendant enjoys many privileges, but when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy a Fifth Amendment privilege as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril. They have an attorney-client privilege. But when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies. And there is no reporter privilege in Massachusetts. And so what has happened in this interview is that we have 3 attorneys, a defendant, and a reporter having a free reign of interview, and then later deciding what parts of the interview they want the public to hear, what parts of the interview they want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law, to protect statements that the defendant or their attorneys made that they don't want the Commonwealth to learn about, is just wishful thinking. That's all it is. And
wishful thinking, ouch. Sometimes he has these just offhand remarks where you go, ouch. It's like, this is just wishful thinking. She had her lawyers there, but this is why your lawyers, she wants it both ways. And this is a point Lally made. You can't say that I'm going to assert my Fifth Amendment privilege, or my right to remain silent, not incriminate myself, and talk and promote yourself and promote this innocence fraud campaign and talk to everyone. You can't do it. You can't say after you've talked to, this is why lawyers, and if you listen to my episode with fantastic lawyer Tom Mortati, he's a civil lawyer, he's following this case. He's coming back on, talk to more Karen Reed. So excited. He said the thing I would tell Karen Reed is to not give any interviews. Be quiet. Because the more she talks, the less options the defense has. But last time, they just got away with it. So much of the interviews that she gave were not allowed in. Or not given in time, or not useful. It's not useful to have 150 redactions, Gretchen Voss. Context is important. And even those denials are important. And Karen Reed knows this. And I think when you'll hear her lawyer, we're going to stop for comments in a second, but you'll hear Gretchen Voss's Boston Magazine lawyer come in and with what I call the samesies argument. We just want samesies. Last time we didn't have to hand it over. Samesies. I call samesies. It's a different trial. I think a lot of this stuff is coming in. Be curious to see how much Judge Cannone limits it? I wouldn't think very much. Because by limiting it, you're also, if it's exculpatory, then it should help Karen Read. All this should help Karen Read. Everything they're asking for should help Karen Read if she were innocent, right?
You know, I'm not oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably, all three of the attorneys are witnesses as well. Now, Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position. But they're all witnesses to a substantive statement, many of them admissions of guilt, contradictions, all of them, in the most respectful way to pursue those, the strongest way, the fairest way to pursue those, with moderation, is to get them from Emily Voss in the interview that exists. Now, in the pleadings, I received the response this morning. I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on two propositions. Number one, Commonwealth versus Doe, promulgation, those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it, she said it. There's a difference, and Your Honor pointed out in that hearing. Could you give me a case that talks about confidential information as it does confidential informants? And respectfully, there was no case to be produced because there is none. The cases are dissimilar because they deal with trying to get to a confidential source that may expose a source that never may not be used at trial anyways because it's based on hearsay or there's no factual basis for it. This is not a confidential informant. The defense chose a strategy, a very strategic strategy, to sell their story and disseminate to the public, potential jury pool, in a way.
Right. This is a very interesting argument here he's making. He's saying, look, sometimes reporters will say, look, I got this information from a confidential source. Sometimes they'll go even to prison to not give up their confidential sources when demanded. But Karen Read is not a confidential source. They have no factual, there's no law that says they shouldn't hand this over. And you'll hear how thin her lawyer's argument is. I'm not joking when I say it's the same as his argument. Last time we didn't have to hand it over, but Judge Cannone left it open for the Commonwealth to argue it again. And just a note about innocence fraud campaigns. When you get a convict out, the way this movement works is it is partially money-oriented, money-motivated. It's also motivated by an ideology to push, but it's partially money-motivated. And that is really what keeps the thing going. It's very hard to stop something that's making everybody a lot of money. And if Karen Read is acquitted, she will absolutely sue the police for false arrest, false imprisonment, the state, etc. And it often is the taxpayers that will pay these multi-million-dollar settlements should she get it. And those are done in our civil courts where the bar of evidence is much lower. It has to just be more probable than not that it happened. It's not beyond a reasonable doubt. You don't have to meet that burden. And so often that these guilty people walk off, it's usually about a wrongful conviction, not a wrongful arrest, but walk off with multi-million-dollar settlements. settlements or judgments. So I am convinced that Karen Reed will go that way. She's very knowledgeable on innocence fraud. She has schooled herself on this topic. And like Amanda Knox, she wants to be the next poster child for wrongful arrests, wrongfully accused, and possibly if they get her out, if she actually gets convicted of something and they reverse it and get her out on some kind of appeal or campaign. So meaning if this campaign goes on after conviction, she will sue and often win. They often win. They just got Melissa Lucio out in Austin, Texas. Check out my Twitter for more information on that horrible, horrible case. Awful. Austin, Texas. Shameful, shameful, shameful.
They thought best fit their needs. And they've done this continually. And although an attorney cannot produce evidence to the public or encourage it, it violates the rules of professional responsibility. They cannot have a statement that is meant to reach the potential jury. A defendant can. The Commonwealth does not resent that Ms. Reed has made statements to all of these different outlets. She's entitled to. She's presumed innocent. She can make all the statements she wants. But when she does, there is a consequence for that. And they now bear the consequence of these statements that have been made. And so, since it is not a confidential informant, it's a very public, identified person, it's Ms. Reed herself, the argument of Doe and promulgation has...
Gosh, look at that face. She's entitled to make all the statements she wants. But when she does, she's got to know that they can be used in trial. She had her lawyers there. They did inform her of the risks of doing it. But Karen Reed knew to convince the public that it was crucial that she make these connections with journalists who would show the best face and show her innocence fraud narrative and write it and edit together pieces that showed her side of the story as the only story. This is why it's so important for the O'Keefe family to get out as a family and give interviews. People can only feel sympathetic to what's put in front of them. And my fear is that they've signed away their rights to do any interviews until Gretchen Voss's Netflix series, that's not going to make any difference, comes out post-trial. I hope, and I think I wouldn't know what the ramifications were if they were to defy that, but I think they should. And they are always welcome. John O'Keefe's friends or family, always welcome to come on this show and talk about whatever they want, whatever they're comfortable with, for however long they want. It is an open invitation.
No merit. I know Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize. In this case, firsthand, I have never seen anything like this, where witnesses have to fear walking out of their car. It's repugnant. It undermines the fabric of the judicial system. But Ms. Voss isn't...
Look at that. So, Egbert, it's like, it's repugnant that witnesses are afraid for themselves and their family and their children. It undermines the fabric of our justice system. And Karen Reed tilts her head, very pleased with her handiwork there, and very annoyed at Mr. Brennan for not appreciating all her good work with her harassment campaign, because she's the mastermind of that, my opinion. And I think the evidence shows that in Aidan Carney's case. I mean, go back to my last two episodes.
Alone, and I have empathy for her. Almost every witness, civilian witness for the Commonwealth, has sustained similar or far more egregious abuses. It is awful to think the level of harassment and intimidation that someone must suffer because they're simply a witness in a case. And my empathy is to Ms. Voss, but to every other witness in this case, she's in no different position. It does not impede the progress of the Commonwealth. It does not impede the fact-finding mission.
Right. So you didn't redact those two interviews 150 times because you're scared. And if you did, you know, protecting Karen Reed has not stopped you from being in fear of her harassment campaign. Sorry, harassment campaign argument, which is one of their arguments, not good enough.
It's unfair. It shouldn't happen. Something should happen as a result, but it has no bearing on the analysis in this case. It just doesn't. And so there is a ton of conversation that has been redacted arbitrarily by parties that want to use what's in their best interest, but cover up what doesn't help them. The Commonwealth is entitled to it. And we're seeking it and we want it. We want all the redactions in the first and second interview. Over 75% of the second interview is redacted. We want the notes from the third interview. Ms. Voss is a witness. She wasn't at the scene. She didn't see Ms. Reed drive into John O'Keefe and leave him in the snow. But she's a witness to substantive statements. Her statements. Admission.
Interesting. So 75% of the second interview is just gone, redacted. And I'm sorry, Gretchen Voss, but your argument that you're afraid to hand these over unredacted for fear of being targeted in her witness harassment campaign isn't good enough. Does everybody get that? She's saying, I can't hand over these unredacted tapes and my notes because I'm in fear. I'm in fear for myself. Sorry, not good enough. You have to hand them over, and she's a witness. No, she didn't see John O'Keefe get hit, but she is a witness in this case nonetheless. I hope we'll have time. I want to keep this short, but I hope we'll have time for her lawyer.
Confessions. And those notes evidence the statements of Ms. Reed. They're clearly discoverable. And the email or text message and phone call, again, statements of the defendant. Ms. Voss, reporter or not, is a witness in this case to some of the most crucial damning evidence in this case. We're entitled to it. We take no exception for it. Thank you.
All right, thank you. Mr. Birch.
Thank you, Your Honor. Robert Birch for Metro Court and Gretchen Voss. I've been here before, Your Honor, on a remarkably similar motion.
I'm going to remove Mr. Birch for a second, get to your comments really quickly.
We got your comments. You had something to say. You were insightful. Oh, so clever. So Roberta's going to read your comments. Hey, Roberta, read those comments.
Okay, the comment section was cracking. Carla Bannock, 1460, says, True Crime Report, more gossip and gossip report from Holland. Well, that gossip was a police interview, so that's gossip. I don't know. John Barclay, 2767, left one of the nicest comments I've ever gotten. I just want to thank you for the incredible work you do on exposing innocence fraud. Your podcasts are some of the best I've come across. Thank you. So well-researched, compelling, and thought-provoking. It's clear how much effort you put into uncovering the facts and presenting them in a way that's both accessible and impactful. Your content not only sheds light on important issues, but also inspires people to question narratives and seek the truth. Keep up the amazing work. You're making a real difference. Thank you. Stephen Price, 6957, says, this case is so strange. Well, it should be just a person in jail for a hit and run, but here we still are. I've got a theory on why Karen is saying in interviews that her music was blasted so loud. She's trying to say that she didn't hear the beeping when flying in reverse. My music was too loud, etc. That's how this woman works, planning ahead. Conniving, manipulation is Karen's way. Sure is. That's interesting. She didn't hear the beeping because the music was so loud. What about the flashing? I don't think so, Karen. I don't think that's going to fly. But let's see. I believe this is pretty brief. If it's not, I'll stop it. But this is Gretchen Voss's lawyer. Take a listen.
And Your Honor, at that time, made a Solomonic decision and said that 2 audio tapes minus attorney dialogue and off-the-record comments would have to be produced. And the one-on-one off-the-record interview between Gretchen Voss and Ms. Reed did not have to be produced. And the Commonwealth has simply made no persuasive showing as to why the decision should be any different now. The Commonwealth makes much of the fact that there are heavy redactions on the shorter of the 2 taped interviews. They refer to it as a 2-hour interview. Actually, it was a 1-hour interview according to the affidavit of Gretchen Voss, which had been submitted with our original opposition to the first motion. So it wasn't quite as lopsided as counsel is intimating.
Okay, so if it's 1 hour and not 2 hours, the interview is what Mr. Birch is saying. If that's true, she handed over 19 minutes. What is that, 60%? I mean, I don't know. It's a lot missing. 80% missing?
But in any event, the reason for the redactions is that the Commonwealth made a point in its original motion that it was not seeking anything but the defendant's statements, that it did not want colloquy of attorneys. It did not seek what the attorneys were saying. And it said that over and over in its original motion. Now it's suddenly changing the rules and says, oops, we've decided we want those after all.
Didn't I leave that open for them, though? Didn't I leave that open for them to come back, even at the first trial, to come back and request it upon review of the first release?
I'm sorry, I didn't quite.
I left that open for the Commonwealth to come back the first time even, right? The first trial. And we have here now a new trial. We have different attorneys presumed with today's motion on both sides. So why are we focusing on what they requested first and what's different than now?
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is, why do they need that more? They had made a determination at one time that in order to be fully prepared for trial, they only needed a certain amount. And they only did not need attorney's colloquy. And now they're saying the attorney's colloquy is central to what they need. They can't have it both ways.
What do you mean? Yes, I can. She left it open for them. She's like, yeah, they can have it both ways. Told them that they can make another request and they can change the request. And Mr. Birch looks like he's struggling to hear. He's older. He's not this slick attorney that Karen Reed, image conscious attorney that Karen Reed respects. And you can see her kind of rolling her eyes and flipping back her hair and looking behind her when he talks.
Okay, go ahead.
The change of subject from one before and after a colloquy, he says, bears on the credibility of the defendant. But if the defendant contradicts herself in the course of an interview with Gretchen Voss, I fail to see how that has the impact of serving as grist for impeachment at trial.
Sure does. Sure does. Because she made contradicting statements. It shows that she's lying. There's only one truth. He knows that. This is the weakest argument. We'll get back to it next time. I'm going to stop right here for tonight. It's a very interesting hearing. I don't want anyone to miss any of it and get too bogged down with too much stuff. So I'm going to leave that for tomorrow, day before Thanksgiving. Certainly a busy time for me. I don't know about everybody else. Anybody else stressing out? But before anyone else stressing out about Thanksgiving, trying to do everything. Before I leave, I'll leave you with Karen Reed at her party. We may go over this again. Gave us a short speech. Let's take a listen. I'll leave you on this. To her supporters. So this was a dinner she held for her supporters, with her in between her brother and her father.
One of the worst losses, other than the physical losses of this nightmare, has been the loss of my reputation. And I feel like I have it back in spades because of the people in this room that embraced me despite hearing horrible things. One of the worst losses, other than the physical losses of this nightmare, has been the loss of my reputation. And I feel like I have it back in spades because of the people in this room that embraced me despite hearing horrible things.
Despite hearing horrible things and compelling evidence against me, one of the most horrible things was the physical losses. Does that mean the loss of John O'Keefe? Is that a physical loss? What a weird way to put it. It's like, I'm the banker. In terms of checks and balance, this was a loss, but you made it a win. And the worst part was the loss of my reputation, not John O'Keefe. Unless she's saying that's a physical loss. The money loss was the worst. Is that the physical loss? What is the physical loss? What is the physical loss, everybody? Oh, the narcissism. Cold, stoned psychopath. That's all I have to say. I'll leave you on that for tonight. Have a great night, everybody. I'll see you tomorrow at 6.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down. accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system, my clown. Innocence fraud campaign to save my skin. Making money, truth is my side.